This is the presentation that for 42 years I dreaded making and knew that at some point I would have to make. The current Supreme Court majority is a major threat to science and secularism. Now, most of the work that CFI does involving the Supreme Court has been in the realm of separation of church and state. CFI counsel Nick Little and I have filed numerous briefs with the court arguing why the religious right is wrong when it asserts that government can favor belief over non-belief and that government must show religious objectors a special right to avoid complying with laws that are binding on the rest of us. Today, we're going to focus on how the now 6-3 religious right supermajority on the United States Supreme Court issues rulings that defy scientific evidence. We will see how the court rejects science as part of the effort to undo church-state separation. We'll also see how the court dismisses scientific evidence generally in order to achieve its other ideological objectives. When the religious right supermajority tells us that they're not motivated by religion, but they're just interpreting the Constitution as they see it, it's like when the casinos in this town want us to earnestly believe that they want us all to gamble responsibly. We must now confront the awful tragedy that the one institution of government that we could most reliably trust to protect our personal freedoms and make decisions based on reason from about the late 1940s onward has become a weapon for imposing religious tyranny and ignoring the very science it used to revere. I want to give you an example of how the court once used science and how it understood science. Very interesting history. 1993 case of Daubert versus Merrill Dow Chemicals, the Supreme Court actually set forth criteria for determining if someone who claims to be a scientific expert should be permitted to testify in the courts. And the court ruled that any supposed scientific explanation, in order to be admissible, must be capable of empirical testing, and quoted Karl Popper by name. The court then actually set forth its own definition of knowledge, writing that the word knowledge connotes more than subjective belief or unsupported speculation. The term applies to any body of known facts or to any body of ideas inferred from such facts or accepted as truths on good grounds. Almost sounds like a speaker we would have at this conference. The court then explained how a study of the phases of the moon might be relevant as to whether a particular night was dark if darkness were an issue in the case. However, it would not be admissible to show when a full moon appeared if the purpose was to argue that full moons impact how people behave. In the 1999 case of Kumho Tire Company versus Carmichael, the court said that some categories of claimed knowledge are so inherently unreliable that supposed expert testimony based on them would never be admissible, and the court cited astrology and necromancy as examples. However, the fact that the court gave its criteria, which is in line with scientific reasoning, does not mean that the court explained what the court should do once the evidence is admitted. Now, we are lucky that the court had not yet fallen to these barbarians the last time it decided an evolution and creationism case. We were fortunate that the court did not yet have a religious right-wing majority in 1987 when it decided Edwards versus Aguillard. Louisiana passed a law requiring that creationism be taught in public schools alongside evolution in order to provide a so-called balanced view. The state argued it should be given the chance to demonstrate that its law was not based on religion, but on a sound scientific theory about how everything in the universe, including us humans, suddenly appeared in our present forms. Nothing to do with religion. We won 7-2. However, the two dissenters, no surprise, Justice Scalia, joined by then Chief Justice Rehnquist, argue that Louisiana should have a chance to demonstrate its claim because there are numerous reputable scientists who agree with the spontaneous, sudden appearance of everything in the forms we have today, assuring us that they don't need to base their assertions on any deity or supernatural being. It was frightening to see then how two of the most well-known justices in modern times dismissed science to clear the way for government to promote pure religious beliefs. It's even more frightening that that minority of two has expanded to a supermajority of 6 today. The present Supreme Court majority demonstrated contempt for science these past 2.5 years by carving out special rights permitting only religious objectors to avoid complying with otherwise society-wide COVID safety measures. In late 2020, after Amy Coney Barrett replaced Ruth Bader Ginsburg on the court, in the case of Roman Catholic Diocese of Brooklyn versus Cuomo, that's a good name for a case, the court misused the concept of free exercise of religion to strike down restrictions on the number of people who can gather for worship services. At the time, Governor Cuomo adamantly, to his credit, insisted that the religious should not have special rights to infect society. And this case was brought to the Supreme Court. Now, the court sided with the religious claims and essentially gave religious objectors special rights not to comply with COVID restrictions. Now, in dissent, Justice Breyer pointed out that the rules that New York State put into place applied to similar meetings, lectures, concerts, theatrical performances, wherever people are gathered and are more likely to be in close contact for longer periods of time. Then Breyer argued that the court's precedents recognize the importance of allowing individual branches of government to set health and safety standards when there is a health or other emergency. And this certainly was the case when New York State, beginning in March of 2020, had to deal with the COVID pandemic. But then Breyer also very pointedly lamented the majority's decision because it rejected clear scientific evidence that shows us how the virus is transmitted from person to person through respiratory droplets that are produced when people are in a group, talk to each other, sing, cough, or breathe near each other. Breyer mentioned that the Supreme Court majority even rejected the scientific arguments of the World Health Organization and the American Medical Association. The risk of transmission of COVID is higher when people are in close contact with one another for prolonged periods of time, particularly indoors. And then Breyer, to his credit, specifically emphasized how the court majority was intentionally disregarding crucial scientific information that would reduce the harm of COVID just so that religious objectors could be exempt from complying with these essential laws even if it means that these religious objectors could collectively jeopardize the general public health. At this point, I want everybody to understand the purpose of the Free Exercise Clause. The first words of the First Amendment are, "Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof," the words by which we church-state separationists literally live and die. The Free Exercise Clause was designed to protect those with any viewpoint on matters of religion, from fundamentalists to atheists, from suffering fewer legal rights than those with different points of view. It was never meant to provide religious protesters exclusive, special rights to avoid complying with generally applicable laws, particularly when those clauses are crucial to public well-being, and in the case of COVID, the survival of millions of people. Then in 2021, in South Bay United Pentecostal Church versus Newsom, again, the 6-3 supermajority voted to strike down a number of COVID restrictions that California had in place regarding indoor services. There were 3 sets of restrictions the court dealt with. One prohibited all religious services in Tier 1, areas of California with the highest infection. Another restriction limited religious gatherings in other parts of the state to 25% of capacity. The third restriction prohibited chanting and singing without masks in close quarters. Now, the court did uphold the latter one, which shows that the court will make an occasional nod to science as long as it can disregard it overall. But other than that, the supermajority struck down the other restrictions, and it allowed indoor services anywhere in the state, regardless of the level of infection. And then the court even invited religious institutions to submit evidence to it directly if these institutions feel that their right of free exercise of religion was being hampered by COVID restrictions. So in other words, the 6 religious right-wing justices who control the Supreme Court actually asked the religious bodies to help them make sure that the religious have special rights to endanger the health and safety of everyone. Now, there were only 3 justices on the church-state separation side, Breyer, Kagan, and Sotomayor, and Breyer has now been replaced by Ketanji Brown Jackson. Kagan wrote a powerful dissent, joined by the other 2. She said that the state did not single out religion for special deprivation of rights. She pointed out how political meetings, lectures, movies, plays, concerts, the hospitality industry, that religion was simply grouped with all these other types of activity to have a uniform defense against the spread of COVID. And in preferring preferential treatment for religious gatherings, the court majority even ignored scientific evidence. Look back to the 90s, the cases that I just brought before you, where the court talked about empirical evidence being crucial in the decision of cases. And yet, even though California provided experts showing how shopping for groceries differed from worship services in the amount of droplets to which those engaged in either activity were exposed, Kagan also wrote, "This is no garden variety legal error in forcing California to ignore its actual scientific experts and their findings. the court impairs the ability of the various states and their effort to address a most severe public health emergency. Now, in the realm of pure science, we're about to look at a harmful, dangerous, and ridiculous case. In June of this year, the court issued a 6-3 ruling that brazenly ignored the scientific evidence of how climate change threatens the nation and the world. With no actual constitutional basis whatever, the majority deprived the Environmental Protection Agency of the power explicitly granted to it by Congress to curtail greenhouse gas emissions. This preposterous decision was fabricated for no reason other than political support for the business interests of power plant operators and the states in which they are located. In West Virginia versus EPA, the court majority voted to strike down regulations that Congress clearly empowered the EPA to promulgate under the Clean Air Act. Now, there was no constitutional basis for this, but yet just a week before deciding this decision and inventing things that are not in the Constitution to block Congress from empowering the EPA to regulate the emission of dangerous greenhouse gases, the court majority obliterated almost 50 years of protecting abortion rights under the Constitution. The rationale in the majority opinion by Justice Alito was that the term abortion appears nowhere in the Constitution. Yet in the EPA case, the court majority invented out of nowhere something called the major questions doctrine in order to have an excuse to invalidate powers to regulate greenhouse gases that Congress conferred on the EPA. And now this major questions doctrine, the court says the Constitution required Congress to be more specific, that the EPA couldn't just oppose and couldn't just block the emission of pollutants generally, but the court put in the ridiculous requirement that the Constitution required Congress to specifically mention greenhouse gases. There is no basis for this in the Constitution. In fact, if you know the United States Constitution, under the Federal Supremacy Clause, Congress's right to create such an agency and delegate power to it is absolute. Now, in dissent, Justice Kagan wrote that there was no basis for this decision, and she concluded by saying, "The stakes here are high. Yet the court today prevents congressionally authorized agency action to curb power plants' carbon dioxide emissions." And then she says, "The court appoints itself instead of Congress or the expert agency as the final decision on climate policy." And then, direct quote from Justice Kagan, "I cannot think of many things more frightening." Well, either can we. Former California Governor Jerry Brown once said that those who want to make the world a better place can proceed under three broad categories: to protect the earth, serve the people, and explore the universe. There's nothing in these three rubrics that is not gravely threatened by a Supreme Court that will reject science in favor of imposing religious exceptionalism on society and in favor of those who demonstrably harm the planet. The religious right-wing takeover of the Supreme Court that I've been literally screaming about for 42 years has unfortunately happened. The only way we have any possibility of again being protected by the types of court majorities we had in the past is from now on to treat every presidential election and every election for the U.S. Senate as a referendum on the court. Because Whether church-state separation and pro-science justices can be successfully placed on the court when there's a vacancy will depend on who will be president at the time and what the composition of the Senate will be. Whether it takes the rest of our lives or even a number of generations, we must do everything we can to ensure that at some point there will once again be a court majority that follows reason, science, and the true meaning of the religion clauses of the Constitution was to secure equal rights for believers and non-believers. This means that we could once again have a court majority that would never allow any branch of government to favor religious believers over atheists, agnostics, and other religious dissenters. In April of 2019, Justice Clarence Thomas openly questioned why we atheists even take oaths since we don't believe in a supernatural enforcer. Well, he got it wrong because he doesn't understand his own religion. If you are a saved Christian, there's nothing in the New Testament that says you lose your salvation if you lie or commit perjury. Once you're saved, you're saved. You are saved by faith alone. And if you're a Catholic like Thomas and you lie under oath, all you have to do is go to confession and the priest will tell you to say a few Hail Marys, take 2 aspirin, and call him in the morning. So that's certainly, but in addition to that, Thomas and Justice Neil Gorsuch believe that each state should be able to have its own official religion. Its own official religion. When Justice Scalia was on the court, he wrote in dissent, "The First Amendment permits us to disregard the devout atheist." In a 2013 interview in The New Yorker, Scalia said that atheists, though well-meaning, are being duped by Satan, who he claims to believe in, into thinking there is no God. Now, Scalia probably had proof of Satan's existence every time he looked in a mirror. And so, given that there's actual anti-free thought prejudice on the part of Supreme Court justices, if our beloved Martin Luther King were with us today, I would beg him to admonish the court and the nation that all of us should be judged not by the content of our theology, but by the content of our character. We must have in place someday a Supreme Court majority that would never, ever allow religious objectors special rights to jeopardize all of society just because they don't want to comply with public health orders. We are dangerously close to an anti-science theocracy, something else which very few people know about. The religious right, led by Trump crony Steve Bannon, has been working on establishing for the first time since 1787 a whole new constitutional convention where the entirety of the U.S. Constitution could be thrown out and rewritten. 28 states have already voted for this to happen. They need just 6 more. Everything would be up for grabs. Nothing could be called unconstitutional because the Constitution itself could be entirely eliminated and replaced with the most theocratic, with the most anti-scientific, with the most oppressive laws. And so it is that we, scientific skeptics and secular humanists, have to play a role, and it might take the rest of our lives and beyond. But it's up to us to make sure we are involved in the effort to restore science, reason, and secularism to the government of this nation, and to make sure, if we can, that so much of modern civilization never again vanishes from the face of America. Thank you.